when you wear your weaknesses like a badge of honor, nobody can use it against you.
Meet Fola Alade, a legal powerhouse with over 18 years of elite practice and a global pedigree in ADR. As the visionary founder of FOTEFA, Fola is revolutionizing how Nigeria resolves conflict. Trained by one of Africa's premier mediation organizations, he is the globally recognized expert turning legal battles into business breakthroughs.
Dispute is not going anywhere. It's as old as mankind. People are impatient. It is that impatience that mediation is trying to capitalize on. Mediation is the only form of dispute resolution that brings about the possibility of restoring relationships. Now, one other cornerstone of mediation is confidentiality. When you say it's without prejudice, what that essentially means is that everything that is said there cannot be used as evidence in court. And I belong to the school of thought that says that there can be a peaceful coexistence of every element of dispute resolution. And I tell everybody that cares to listen, it is no longer a question of if, but a question of when. Mediation will become the future of dispute resolution.
Hi guys. So he's not motivated again, and I think we've actually gone full circle in all the things we've been talking about. I think one of the things I personally enjoyed about these conversations is how unplanned some of them are. A lot of times you start with, oh yeah, let's just ask this question, then we end up on another angle. But the beauty of it is that it has brought out a lot of truth in what really are problems ingrained in our society. Sometimes we sit down and we're like, oh yeah, Nigeria is just this way, or this thing is just like this. And you find out that when you actually see with somebody who knows what they're doing, it's one of those areas where you're just like, okay, maybe we didn't know much anyways. So one of the things I also learned recently is that a lot of times, most of us get into disputes and we're like, oh yeah, I need a lawyer. I'm going to sue you. And it's just, you end up not going to court because you go to court, you spend 10 years in court, or you spend some long number of months, and it's not very encouraging to people. But there are other alternatives in law. And one of it is basically mediation. And it's an area of law that I for one, never knew it existed until very much recently. So with me today is one of the leading mediators in Nigeria that I basically found to be extremely, I always call him a philosopher, really, when I read anything he writes, because he's one of those people that speak from the heart, and he says things the way they are. He's a very good friend. Fola Alade, I think FOTEFA, when I heard of FOTEFA first time, and I was like, why would somebody name something FOTEFA? Maybe tell me why. Why that name?
Okay, so FOTEFA is an acronym for my name, my wife, and my 2 kids.
Oh.
Yes. So the FO stands for Fola.
Interesting.
Yeah, then the TE stands for Teju.
Okay.
Now, the F stands for Farah. That's my first daughter. Then this A stands for Anoluwakibati.
Interesting.
So it was just basically a combination of words to come up with FOTEFA.
If anybody wants to insult you with FOTEFA like this, must be ready to fight the whole family. Yes. Okay. So, but I think, walk me through. So, what's FOTEFA about, really?
Okay, so FOTEFA is a commercial bespoke mediation firm, and essentially what we do is to resolve disputes for clients amicably without having to go to court. So essentially we do 2 things. We save clients money, and then we resolve the disputes amicably. So that's essentially what the commercial law firm of FOTEFA is all about. But it starts from somewhere, which is mediation. So, and mediation really has to do with an amicable resolution of disputes with the use of a third party called a mediator. Now, but we have expanded that framework to even include other things. Inclusion in the sense that even if you don't want a mediator to resolve the dispute for you, and you want us to represent you in a dispute, we do that. So apart from resolving disputes, we also represent clients to resolve disputes. Apart from also doing that, we facilitate, we consult, we train. So the end goal really is that dispute, conflict, halfway, misunderstanding, disagreement is innate in us. So you do not need to be at loggerheads with people. So it's just basically a framework of trying to have them resolved. That is basically what mediation is all about. And it also stems from the fact that having spent over 10 years in active legal practice, I accidentally stumbled upon mediation, and then it's been that way all through.
I like that word accidentally because it looks like something, because I've never really seen people go through that process.
Interesting.
Honestly, in my entire years of being part of different sort of conflict, what I see is usually big lawyers on this side, multiple lawyers on this side, boom, 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 boom. And I'm like, okay. So, but what I want to understand, so let's take to an average person. So the people watching this, basically, I don't think, I'm not knowledgeable in law. Mediation is, okay, you said dispute resolution, but
Okay.
what does that really mean to a normal human being? If I'm sitting down now and I'm like, I want to paint a scenario. Okay, I went into a contract with someone, the person did not honor the contract, and I say, I want to fight you. Let's go to court. From that point of that conflict, please help me explain what mediation is from. Like, oh, you don't honor my contract, I'll deal with you. You deal with me. Okay, let's go. What happens?
Okay, maybe I can just take a step backward and explain to you how how dispute resolution really is all about. First, we have litigation that everybody's familiar with.
Yes, that one easy.
Litigation is easy. We go to court, we slug it out and all of that, and that's what most people are used to. So I can call that, first of all, the tree of litigation, going to court. Now, on the flip side, we have what's called ADR. That's called the tree of ADR.
ADR.
Which is an acronym for alternative dispute resolution.
Okay.
Yes. Now, ADR really refers to any means of resolving disputes outside the courtroom. So that is what ADR is all about. It's a tree.
Is this what people call settlement?
Alternative dispute resolution. It's basically, so the imperfection, the issues of litigation, which you just mentioned, having to spend years in court without end, I'm not sure when the dispute will be resolved, actually gave rise to ADR.
Okay.
Yes. Now, that ADR is a tree that has different branches. Now, I'm sure you've heard of arbitration before, right?
Yes.
Now, arbitration is very popular because it has similarities with litigation.
Okay.
Now, so essentially, arbitration is a simplified way of resolving disputes without the technicalities of litigation.
Okay.
Now, we have quite a lot of ADR branches. Now, we then have mediation. We have arbitration, we have negotiation, and then we have mediation. Now, within the framework of the example you have.
Sorry, you have ADR, you have mediation.
So ADR is a tree.
Okay.
Now, mediation is a branch. You know how a tree looks like?
Okay.
Yeah, so mediation is a branch under the tree of ADR.
Okay.
The tree has roots.
Okay.
Now, that tree of ADR, we have arbitration. Arbitration is popular. Why? Because it's a simplified means of dispute resolution without the complexity of litigation.
Okay, makes sense.
That is why arbitration is very, very common. Now, we have arbitration, we have negotiation.
Okay.
Then after negotiation, we have mediation. Now, mediation really talks about an amicable way of resolving disputes using a third party, neutral. Now, that third party is a mediator. So essentially what that means is that if you're having a misunderstanding with someone, that's a misunderstanding. But if you then bring in someone that has been skilled and taught in the act of mediation, that is essentially what mediation is all about. Because when it comes to dispute resolution, there is a structure, especially where mediation is concerned, towards resolving disputes. That is essentially what mediation is all about. An amicable way of resolving disputes with the help of a third party neutral. Now, why I don't want to use the word mediator again is because we have the word mediation, we have mediator. You understand? So if I say mediation is an amicable way of resolving disputes with the help of a mediator, that would almost sound like tautology. So hence the word third party neutral.
Okay.
So basically a form of semantics.
So back to that, my example now.
Okay. So
I go into business with someone.
Okay.
I performed, he doesn't want to pay.
Okay.
And I'm like, so if I say, let's go to court.
That's called breach of contract, by the way.
Yeah, breach of contract. There's a breach of contract.
Yes,
and I sit down and I say, let's go to court. I'm going litigation. Boom. So that's clear.
Yeah.
Now, most likely, those contracts will come with, if there is any dispute on this, we will resolve it through arbitration, which is what most contracts usually carry. A lot of people will like, oh, if arbitration can now not resolve it, you go into litigation through some.
So it's actually, so the way it usually starts is, we call it the NMA approach.
Okay.
Now, what that essentially means is that, so there's, in every agreement, in most agreements actually, it's like a trajectory of some sort.
Okay.
It's called a dispute resolution clause. Now, that dispute resolution clause states that when a dispute arises, parties will try to have that dispute resolved through negotiation. That's always the first port of call.
Okay.
Now, when negotiation fails, you can then have mediation.
Okay.
Yes. Now, when mediation fails, more often than not, you then have arbitration as the last port of call.
Okay.
Now, so what that essentially means is that, you see, having that dispute resolution clause in that agreement has taken that agreement out of the realms of litigation. Meaning that if a dispute should arise, and there's a clause in an agreement that says that you have to either negotiate, mediate, or arbitrate, you cannot go to court. You would have to follow that trajectory. Now, that is where mediation comes into play. Now, but please understand that even without that clause in any agreement, even if there's no dispute resolution clause, you can still decide, you can elect to go into mediation. Now, let me now go back to what you've just explained to me. Now, you've looked at the option of not wanting to go through litigation because you feel it takes time. You want to settle amicably. So maybe we shouldn't even just be using that word mediation. Maybe it sounds a bit too technical. Let's just say, look, you are looking for other alternatives of having that dispute resolved. You now want to look at mediation. So what happens is that it's one of two things. You can actually you can have a private mediation where you bring in a mediator who will then look at what the issues are and then work both of you towards an amicable way of having those issues resolved.
Okay.
Or you can actually have that case referred to an ADR organization that will then select a mediator for you to have the dispute resolved. Now, I'm sure the next question may be that, so what makes it so different? 3 things. Number 1, it is party driven.
Okay.
So when you say party driven, what that essentially means is that you do not necessarily need a lawyer to represent you in mediation. You can represent yourself at mediation. So meaning that, because if you look at it very well, you had a problem with this person when that dispute, before that dispute arose, you both of you are probably having conversations and whatnot, and then a dispute came about. So who better to explain that dispute than yourself alone? So what mediation is saying is that, look, own your disputes, manage your disputes, but there will be someone to help you guide both of you towards an amicable resolution.
Okay.
And if
go
I
on.
okay,
No, go on.
yeah, and the beauty about mediation, which I always try to make people understand, is that we need to first of all even put the concept of dispute in proper perspective.
Okay.
Dispute is innate in us. We are all born with disputes. You understand what we're doing? Like, if you look at kids when they fight, nobody taught kids how to have disagreements now. They just somehow picked it up. Then, secondly, the fact that dispute is as old as mankind. So maybe 1,000 years ago, if I had a problem with you, I'll probably go and slug it out. You have your sword, I have my sword, we fight and all of that. But what has happened with commercialization now is that rather than slugging it out, you have a form, a means of having the dispute resolved. So dispute is not going anywhere. It's eternal, for want of a better way to put it. So what would invariably happen is that while disputes are evolving, like we're saying right now, the means of having them resolved must evolve. And that's basically where we are right now.
Let me tell you where I'm a bit
confused.
I need to clarify, really, especially for the sake of people watching. So just to give a bit more understanding too. So the first question I'll ask is, who has earned the right to call for mediation? And let me give a bit of context to it. So in this breach of contract conversation I just described, because I think it's the simplest one
people can understand
happen.
Really well. Yeah.
The guy, so let's say I'm on the side of I have not paid. I am the one in breach, and the person is on the other side. the person says, can we find a way to resolve this? If I say no, I am right, can he call for mediation? I don't know if you understand what I'm saying.
Oh, yes. Both, I was
Because-
waiting for you to land. Both of you can call for mediation. Now, let's go back to the analogy you used. Breach of contract between A and B. Let's assume A is supposed to supply B with goods.
Yes.
Yes, A has paid B. Now, for circumstances that we don't know about, apparently there's a breach. A is not able to supply B.
Okay.
Now, B is asking for either a refund or is asking for some form of financial compensation. Now,
Okay.
B can say, you know what, that's the aggrieved party. Let's call the B the aggrieved party. The one B, or B can say, you know, I don't even have the time to spend in court and whatnot. So can we go to mediation and look at a way of having the issue resolved? And what are the issues? First is the issue of a refund. Second may be the issue of financial compensation. Third is to see whether we can take the agreement from point A to point B. Now, that is on the part of the aggrieved party. Now, on the part of the defaulter, that's the A that probably that defaulted, can also take B to mediation and be like, okay, fine. You know, what has happened may probably be situations outside my control.
Okay.
But B is asking for a full refund. Now, chances are maybe the money has probably been used to buy the goods. The goods are still coming and whatnot, and he does not have the money readily available. So he can also take B to mediation and say, you know what, are there ways around this? Is there a way we can manage this situation to the effect that if we have future engagements, I can give you a discount on XYZ, XYZ, XYZ.
Okay.
So contrary, so it does not necessarily mean that it's the aggrieved party that can always take the defaulter to mediation. The defaulter can also take the aggrieved party to mediation. I'll even use a better example. Let's talk about loan applications, whereby which I've handled quite a number of times. You are owing the bank money. You know, at the end of the day, the bank you've signed the letter of offer, which clearly states that you're going to be paying XYZ between a period of time, and now you are in default, and the bank is coming and asking for the money. Naturally, you would assume that the bank should be the one to take the debtor to mediation. You know, but the debtor can even take the bank to mediation and say, look, I'm not disputing the fact that I'm owing you. I'm just saying now that, look, for every day that passes by, interest is going on this money.
Having said all this now, okay, one of the things that along that line, so now you've just said that both of them can go to mediation. But you know, if I go to court and the court calls two parties, those two parties must honor the court. Do I, when you send me to an ADR organization, as you said, me as the person you are taking to mediation, can I decide not to say yes to mediation?
That's a very good question. So one of the cornerstones of mediation, let me just make it, let's say remember the following. First is confidentiality. Then second is voluntariness. Now, so what that essentially means is that you are at liberty to not honor mediation.
Okay.
You know? Even when you start the process, you can decide not to finish it, because you see, mediation only becomes binding when parties have entered into what is called an agreement. For as long as parties are still having conversations here and there, it's fluid, you know, and that's basically, and now you see that element of compulsion, but that is basically what makes litigation stand out. The fact that if you accept the process and you don't go to court, the court can subpoena you to come, you know. But when it then comes to mediation, if the mediation is going through an ADR organization like an LMDC, now you have an ADR judge. Now you see, you can serve the parties that will use. You invite the parties to come for mediation. If they choose not to come, the ADR judge can issue what is called almost like a summons, you know, to compel you to come for mediation.
Okay.
Yes, but understand that the element of compulsion is not to force you to settle. It's for you to come and appear before the judge, ADR judge, and explain to the ADR judge why you don't want to come for mediation.
Okay.
Yes. So that is the element of compulsion that comes into place. Yes. To tell you, yes, so it's like a subpoena. telling you to come to mediation and explain why you don't want to settle. And I've had courts to do that a couple of times with processes come from mediation. They decide not to honor it. Then you then go to the ADR judge to issue them a subpoena to bring them to mediation. And what usually happens with the ADR judge, it's not even forced. It's not an element of compulsion. So tell us why you don't want to come to mediation. So is it because you have a problem with the process? Is it because you don't understand the process? Explain to us why you don't want to come. So, and more often than not, they come and say, well, we don't understand what this is all about. And then the ADR judge explains to them what mediation is all about. And then, and they will immediately fix it. There have also been scenarios whereby a party would be like, I'm not just interested in mediation. The judge will try to find out why you're not interested in mediation. And if you still insist on not wanting to go, the court is not under any compulsion to force you to go. It ends there and there. So,
Okay.
so the element of voluntariness, that's what we call it, can be a shield and be a sword. But you then ask yourself one question. You see, if there's an opportunity for you to have a conversation with someone to have that dispute resolved, why don't you want to exploit? First of all, you don't even necessarily need to bring in your lawyer. It's a case of both of us sitting down to talk. So it's even quote unquote cheaper for you, because it is party driven. So explore that means. But you see, what I've seen from practice is that you who has something to hide does not like mediation. Yes, because if delay will favor you, you most likely will not want to come to mediation, because while you are going to court and being in court for years without end, or even arbitration for months, in mediation you can start a mediation and finish under 2 or 3 hours. And then that brings me to this, which I think you will most likely ask later on. You see,
And we
the language of the conversation about mediation is not about efficiency, because clearly litigation is efficient. Clearly arbitration is efficient. You see, the conversation about mediation is about the language of the 21st century. And what is the language of the 21st century? Language of the 21st century, Amida, is speed. So now, what is technology doing? So let's even leave the bubble of mediation. I want to talk about the bubble. So in mediation, you're a service provider. You're basically rendering services to people. That is the element. That is the bubble of mediation. You're a service provider. Let's leave that. Let's go into the second bubble. And what is bubble? The clients themselves, client, customer, end user. Now, what is happening right now? Everybody's trying to bring in technology, to try to see how they can make their business move faster. Now, what has happened now is that people are now learning from Kodak, BlackBerry, Nokia, because those that refuse to bring in technology, those that refuse to innovate. So because of that, everybody's thinking. So while all of this is going on, of course, dispute will come up. So you cannot imagine a man who is trying to get a software developer to come up with a software for his business. You know how software are like. Do you think that man has the time to spend 2-3 years knowing fully well that in less than 6 months, the software will become obsolete? That is where mediation comes into play. So the language of the 21st century is speed. Now, so if you then bring that back to the first bubble, mediation, Amida, is the technology of dispute resolution. How is mediation the technology of dispute resolution? Mediation is fast. There's speed. Apart from the fact that mediation is fast, mediation is the only form of dispute resolution that brings about the possibility of restoring relationships. Now, when we're growing up, I'm sure you heard this saying that 2 people don't go to court and come out being friends. There's this Yoruba saying that 2 people don't go to court and come out being friends.
It's almost impossible.
Yes. But why? Because there has to be a winner and a loser. So why I'm using this words is because I'm just trying to be as simplistic as possible. But in mediation, there's no winner, there's no loser. Because for A to get what he wants, there must be a level of concession with B. You understand? So it's a case of there's no victor vanquished mentality that comes into play. So let's then now come back to what I mean by mediation being speed being the language of the 21st century. Look around you. People are impatient. You are watching now. Back then, you would watch a movie and you watch a series and wait till next week to watch that series. Now, what is happening right now? We have all that. You have like maybe 10 or 12 episodes being watched. You understand? So people are impatient. Now, it is that impatience that mediation is trying to capitalize on. To say that, look, we don't need to be in court for years without end. It is not even as expensive. I don't use the word cheap. It's not even as expensive as litigation. It's not even as expensive as arbitration. And then even the concept of expense, if we can look at expense from the angle of money. How about expense from the angle of relationship? How about expense from the angle of time? So you see, so that is what is happening right now. And I tell everybody that cares to listen, it is no longer a question of if, but a question of when. Mediation will become the future of dispute resolution.
Okay. So I have one extra question on that particular matter.
Yes.
So now, in the process you've explained, I can tell you I want us to go to an ADR judge.
Yes.
We go, you can say, I don't want to come.
Yes.
The judge would summon you.
Yes.
And you explain to the judge why
you don't want
to come.
Yeah.
So let's play that forward a bit.
Okay.
You explain to the judge, I don't want to come. The judge says, thank you very much, Fola. I'll see you later.
Okay.
Can the document of that ADR conversation, if that case proceed to litigation, does that become a pointer? Is it a valid document does it become a court document? I don't know if you understand what I'm saying.
Oh, perfectly. I was just waiting for you to learn. So one other cornerstone of mediation is confidentiality. So now we're even assuming that now the analogy is that he has honored the judge by coming and telling the judge that he does not want to settle. But how about a scenario whereby he decides to even come for this mediation? You understand? They both have conversations, and what is on the table is not favorable to him. It ends right there. And the conversation there cannot be used as evidence in court. So essentially, that is so when you say it's without prejudice, what that essentially means is that everything that is said there cannot be used as evidence in court. So you cannot take any conversation from mediation and take it to court. Everything you say ends right there at that mediation setting. And now, if even when you settle, there's a confidentiality agreement that says that everything that happens ends in mediation. So you are not at liberty to discuss the intricacies of what has happened with the third party. If you do that, because of the document that you signed, the other party can use it against you. You understand? So that's basically what happens. So back to now give a direct answer to your question. If you say there and then that you're not interested, it ends there. So what that has also done is that you have also ticked mediation as not working. You have explored mediation and mediation has not worked. Then you can then explore either arbitration or litigation. Bearing in mind that there is a trajectory. Before even getting to mediation, you have tried negotiation.
Yes.
Negotiation has not worked. You have tried mediation. Mediation has not worked. And then you have tried arbitration. And I belong to this school of thought that says that there can be a peaceful coexistence of every element of dispute resolution: litigation, negotiation, mediation, arbitration. All I'm saying is that, you see, start off with negotiation. If negotiation fails, go to mediation. If mediation fails, at that point, you have the option of either going through arbitration or going through litigation. I've been a mediator for over 10 years, and I can tell you for free that some of the cases I've handled are cases that should not have smelled the four walls of the courtroom. So I mediate with the Lagos Multi-Door Courthouse and some other area organizations, and also mediate outside of Nigeria. I mediate with the United Nations. And I can tell you for free that a lot of times, most of these misunderstandings, some of them stem out of miscommunication. And you see, now, still within the realm of mediation, the beauty about being a mediator, or even coming to the mediation space, is that, now taking this outside that conversation, is that, first of all, mediation passes the test of universality.
Okay.
Now, what does universality mean? That means that you can be a mediator in Nigeria. Once you have been trained to be a mediator in Nigeria, you can be a mediator anywhere around the world. So if I'm probably going to be looking to Canada or some other country, I don't need to go there and then learn to be a mediator. Now, let me also tell you one thing ADR has also done. ADR has also opened the floodgates to people who are not lawyers to come into ADR.
Oh.
So Amida, what that means is that if you wake up tomorrow morning and then say you want to become a mediator, you can't become a mediator.
Okay.
Now, do you not know the beauty about you becoming a mediator is that when you now come into that space, you're going to become a subject matter mediator because you understand your industry, you understand the intricacies of your industry. So if there's a dispute between two parties, based on your industry knowledge, you're able to have that dispute resolved amicably. So what ADR has done is that it has opened the floodgates to non-lawyers to come into the space of dispute resolution to assist in resolving disputes. So the summary of what I've said is that ADR is not only for lawyers. You have non-lawyers that can come and play in that space. And believe me, a lot of them are coming and they are playing in that space and doing that job very, very well. Because if I'm going to go into, let's talk about maybe production, like we're doing right now. You understand the intricacies of production. So when you come in, you not only have the mediation knowledge, you have the industry knowledge.
True.
If I'm going to come into production, I have the mediation knowledge, but that mediation knowledge will be guided by general knowledge. So I will do a good job, but you understand, but chances that you will do a better job because if the production manager is coming up with things that as excuses, you are in the business, like this thing does not make any sense now. I've done this. You are able to speak your language to him. He then understands it, and there you go. You have the case resolved amicably.
Okay, now my brain is full. So let me now, because I think the big problem is, and this is, it took me a long time to understand this thing I'm about to say. And most of us, when we let's take a simple job offer. When we go to work, when we want to take a job, how much do you want to earn? I want 1 million naira. They send you an offer letter that has 7 pages. You check the 1 million, you sign. A lot of us. So, and I can tell you that mindset, even until the time I became CEO, I was not reading my contract. Once I don't see the money, money don't do there. So the rest, they can't dupe me now until I had to leave my first job as CEO. And then I was like, but this is not fair. No, but you signed it. I'm like, no. Okay, but this is not. So, and that case got me really riled up in the sense that I remember going to a UK lawyer because it was a UK court case. And the UK lawyer said, according to UK laws, you have a case. But there's a but. He said, the case would have applied if you were not a CEO. So because the assumption of the law is that as a CEO, you have resources to get a lawyer, to get this, to get that, to get this. That the benchmark for those sort of law cases in Court of England is for people that are earning below $10,000. And I'm like, okay. And the guy said, see, you have a case on a lot of other side, but on the side you're going, you're not going to find anything because the assumption remains you should have gotten a lawyer. And I was like, no, they didn't let me get a lawyer. He's like, no, that does not hold anymore. Yes, because it was like a lot of counter charges. But that particular one was a major factor. And it was simply around, there was a few issues around the compensation factor that were not properly disclosed, that were not fully stretched out. And they were like, no, but this is what we mean. And the guy is like, no, but you would have gotten a lawyer to do it. And he said, no, it's all those sort of things. Because normally, that's when I realized that in UK court, any contract signed without a lawyer, especially when you are in the low income bracket, is almost non-valid. You need to tell the person, make sure you get a lawyer as the employer. Now, what I'm not trying to, so where am I driving? So let's go back. So a contract comes to you and it says, all disputes, and I'm trying to read it in the most expressive way I can. All dispute in this contract would be governed by the laws of Nigeria and subject to, let's go with your framework. First, negotiation. If negotiation is unable to, if you cannot reach a conclusion with negotiation in the next 10 days, we go to mediation. If you cannot reach with mediation in the next 20 days, we go to arbitration. If you cannot reach in 30 days, we go to litigation. Let's assume that that's the contract. You have that sort of contract in your hand. When I now have a dispute, do I have to totally, do the other party have to honor that contract if I say, come to mediation?
So the first question we need to ask is this: why didn't you read that contract?
Me, I read the money now. That's the one.
You know what? Because let's go back. You know the funny thing is here. What is an agreement? What is a contract? A contract, it's a case of, okay, fine. I want you to do X, Y, Z, X, Y, Z. Do you have an understanding of what it is that you need to do? You said yes. Now, that understanding has now been captured in black and white. So when you pen your signature, that signature is an indication that you do not only understand what has been said to you, you have also agreed to it. Now, what can vitiate that contract? Maybe duress. Maybe you were forced to sign. So if you're not able to establish that, then you don't have a case of misrepresentation. What that essentially means is that what was explained to you was not what was put in black and white, and then you sign. But another vitiating factors, but when you don't have all of that, and you then assume that and say, oh, I did not read the agreement, then the question now is, ignorance is not an excuse.
Exactly.
Now, so having said that, if you then decide not to keep to the terms of the agreement, that is where breach of contract comes into play.
Okay.
Now, but at that point, if the agreement states expressly that you can do either negotiation, so the way it works really is this: it's called the NMA approach: negotiation, mediation, arbitration. Maybe negotiation, mediation, maybe litigation.
Okay, but you cannot have arbitration and litigation.
You can't. Okay. You understand? Though more often than not, so the end product of arbitration is an award. The end product of litigation is a judgment. Okay. Now, but when you then have an award, when you get an award in arbitration, you still have to go to court to have it enforced. So at the end of the day, even litigation, even arbitration and
goes to litigation.
Even mediation, once you have a contract and a party does not keep to it, and you want to enforce it again, you still go to litigation. So in this instance, in this scenario that you have painted, it's really very easy. You can still invoke that dispute resolution clause, because obviously a dispute has arisen. You understand? So you can still invoke that dispute resolution clause to the effect that, look, this is what has happened, this is where we are. I would like to renegotiate. I would like to have a conversation around it. So, but then again, you might still negotiate. If negotiation fails, you can still try to mediate. And what is the mediation? Is to try and see whether within the framework of what you have signed, maybe you can probably have another conversation. But understand that where mediation is concerned, it takes two to tango. Now, if that doesn't work, then if the agreement expressly states that you go to arbitration, then you can then come up with whatever reason that you have that has made you come to the realization that you do not want to go ahead with it. But then it still comes back to that particular point in time. Question: why did you not go through the agreement? You understand? Why did you not get a lawyer to help you review that agreement?
But that one is totally for another day.
Exactly. No, I'm just trying to make you because you see, the pendulum swings both ways. Because now let's play the devil's advocate. Now try and imagine a scenario whereby now the clauses in that agreement that you signed, you contested it because it does not favor you.
Oh no,
I'm just hypothetically. So what if when you signed, then the company then comes to the same realization that some of the things we said we're going to give this man,
would you give them back?
You understand? We don't think that we can give it to him. So what then happens at that particular point in time? Okay, fine. What were we thinking? But then again, agreements not agreements. You see. So what I always tell parties who find themselves in this shoe is that understand one thing: the pendulum swings both ways. You have signed. You were not forced to sign. There was no element of misrepresentation. Let's try and have a conversation around those points that you probably did not understand, not the entire agreement. Let's see whether we can find some meeting point of some sort and then take it up from there. So that's basically how mediation can come into place and try to see how we can mitigate the differences.
So now, before I even go on, you see that whole thing, it was a big,
Issue.
call to a bit shocker for me, basically, because it was after that time I met a lawyer that told me, sign every contract as if everything is wrong. And ask yourself, what position would I be? If everything in this thing goes wrong, where would I be? And after then, I started like making sure, okay, you know what? I know another problem that even comes up is a lot of times it's like the doctor's problem, right? When somebody just calls you a doctor, because you don't know what he's doing, you just let the person, examine your body because you assume he's a professional.
He knows what he's doing.
A lot of times, I always say, whatever you do, know your lawyer's capacity. And I say this to anybody in this life. If there are two things you should buy with money first before buying a car, and this is like something, for me personally, I learned the hard way. Before even buying yourself a pair of clothes or anything, get a doctor, get a lawyer. They are extremely, extremely important. So far, you are putting this pen to any paper, there has to be a lawyer with it. But that's my own expert, at least from my own.
It ought to be. They say you cannot lie to, you must never lie to your doctor, your lawyer, your accountant.
Yeah, exactly. You can even lie to accountant. Accountant is fine. That one is just to write book. I can tell you as an accountant, you can lie to the accountant, they'll be all right. Okay. But lie to the lawyer, God help you. Lie to the doctor, well, you'll be all right. You won't even get to lie again. It's okay. But the point is, so that conversation really, it really shook me, because then it was like we had to basically drop that point from the agreement and go after other things and say, okay, you know what? Let's assume we've signed. Let's assume we've done all this thing. Now let's focus on other things. Like, is this what was said? Is this what was written? Does it reflect what was done? So other sort of things. And we started going after others. But even at that, it was still hard. But I want to digress a bit, because I think there's another problem that I see in Nigerian that is causing a lot of dispute, that I think would cause a lot of dispute or is causing a lot of disputes. And I will say it as an hypothetical, as my own, not on an expert point of view, then you can correct me from an expert position. I'm a Nigerian. I live in Nigeria. I work in Nigeria. I go into a contract with somebody and I said, if there's a dispute, we'll resolve this in a UK court. By default, in my head, that agreement becomes almost useless. Not UK law, court. And why I said that was because I had a situation once that said that sort of thing. And I remember going to a UK lawyer like, oh yeah, I want to come to you. And the guy is like, okay, but which judge is going to take a case of a person that does not pay tax in the UK? Has not been to the UK in 1 year or 2 years.
Business was not even done in the UK.
There's nothing came to the UK on this thing. You don't have anything in the UK. But you come and say, oh yeah, I want to come and sue. And the company you're dealing with is not even resident in the UK. So is that a thing? Should people be signing those sort of agreements?
So I may not exactly be able to give an informed response to that, because like I said, I don't do so much of litigation anymore.
Okay.
So this is basically more like a function of law. So I would err on the side of caution and not give an informed response to this. But I get where you're coming from. But the dynamics involved, I would rather not just give it.
Okay, but let's assume this came from a dispute point of view. Okay. And I wanted to come to you as a mediator.
Okay.
Say, okay, you know what? We've signed this contract. It's looking like I don't like this part of it that says UK court. Because I'm assuming a lot of people are going to come and say, I don't sign contract with the UK court. Okay. Should I? Because I can tell anybody that has ever been through that experience that I have been through it.
Okay.
You most likely cannot enforce it.
Okay.
But that's just me.
So if I'm going to look at it from a mediation point of view, now we have what's called the Arbitration and Mediations Act, which technically talks about you being able to enforce any agreement outside the shores of Nigeria. So we have enabling laws enabling sections in the Arbitration and Mediations Act that if you go into a contract with someone in the UK and both of you agree, you can have it enforced there. Now, we also have what is called the Singapore Convention the Singapore Convention, where signatories to the Singapore Convention, if let's assume like Nigeria is a signatory to the Singapore Convention, Singapore, of course, by default, so to the Singapore Convention. So if you go into an agreement with someone in Singapore, and if you mediate and both of you agree, you can actually enforce that agreement not only in Nigeria, but you can also enforce it in Singapore. Why? Because both of them are signatories to the Singapore Convention. Even with the Arbitration and Mediations Act too, you can actually enforce international agreements.
Okay, I need to bring you back on this.
Yes.
Okay. I think I am now confused.
Okay.
But let me just tell you why I'm confused. Are you saying that the Arbitration and Mediation
Act of 2023
gives me the right,
yes,
without mediation, without anything, to go to
as far as mediation is concerned?
Okay, so that's where I was confused.
Yeah, but like I said,
so we're talking about mediation
now.
now.
We're talking about mediation now. Like I said, in terms of other areas, I don't want to hazard a guess because I don't do so much of litigation anymore. And when you're having conversations like this, you want to err on the side of caution by giving an informed response. So that's why, as far as mediation is concerned, that's where I can just give an informed response to that. If you are in the UK, you enter into mediation with someone, and then both of you agree on terms. If there is a default, you can have the mediation agreement enforced then through the Arbitration and Mediations Act.
Oh,
yes, exactly, through the Arbitration and Mediations Act.
Okay, so which means what you're telling me is that in that case, instead of litigating, if the person had gone into mediation,
yes,
and reached an agreement, it becomes enforceable irrespective of the jurisdiction.
If there is a breach. Because you see, where enforcement comes into place is when there's a breach.
Should have known you like 5 years ago.
Exactly. I don't know what I was saying. So the point is that if there is no breach, what are you enforcing? That's the point. If there is no breach, what are you enforcing? Both of us have agreed to do X, Y, Z, X, Y, Z. So if we are both kept to the terms of the agreement, there should be the need of enforcement does not come into place. And you see, that is why what a lot of people but the challenges those we have in the mediation space is not because mediation does not work. It's what a lot of people don't know about mediation. They are yet to know about mediation. You can imagine, I literally stumbled upon mediation. There was a case I was handling in court when I was still in active litigation for 10 years. And then, I did litigation for the first 10 years. And then there was a case I was handling that had been in court for 4 years. And then I went to court and they said the case had been adjourned to mediation. In my mind, I was like, what's meditation? I've never heard about mediation as an English word before. I've never heard of mediation as an English word before. I said, what is mediation? And I can remember going for mediation armed with all my law books and all of that. And I get there and I see a lady sitting down there. She was not wearing a gown. And I was wondering, I was like, what are we doing here? She said, she's a mediator. And I started trying to prove the law. She said, let me cancel. You are representing your client. Mediation is party driven. You should let your party. No. I'm supposed to. But the way and manner she handled that case just gave me a certain type of awareness. And I was like, this is how disputes should be resolved. We came in there and in less than 6 hours, we had that dispute resolved. And apart from even having the dispute resolved, parties shook hands and they walked out of that place happy. That is what dispute should be all about. That is what dispute resolution should be all about. The fact that we had a misunderstanding does not necessarily mean that we cannot make amends and then take it from point A to point B. But you see, a lot of times when you have a conversation with a lawyer and the lawyer is saying, you have a good case. No. Why should you settle? You understand? Whereby they see settlement as a sign of weakness. So these are the issues that are coming up. But I'll tell you what, it's changing. I'll tell you why it's changing, because the parties have started asking the right questions. The first question they're asking is that, okay, fine, can you give me a time frame within which this dispute can be resolved? Well, we can probably do, maybe a year or thereabout, usually more than a year. Okay, don't forget that when a dispute comes up, when a dispute arises, you may start from the magistrate court. Let's say we start from the high court. Maybe a dispute arises at the high court. You get judgment against the person. The person has the liberty to go to the court of appeal. You still go to the court of appeal. Whichever way the pendulum swings, probably the person that gets a judgment against you or you get a judgment against the next person, you still have the Supreme Court. So that means that if you look at the lifespan of a case, you're probably going to spend like maybe 5-7 years on the case. And this is me just managing the number of years, Now, look at the value of what it is that you're trying to get. You look at the time spent. You don't ask yourself one question. Yes, I may have won the war, but I probably even lost the battle. So now, when you then now juxtapose that with our present reality, when you juxtapose that with the language of the 21st century, which is speed, do you think parties even have that time to spend to wait for 5 years? So that's why whenever we have conversations about mediation, I tell them the conversation is not about efficiency, because clearly litigation works, clearly arbitration works. The conversation is about speed. That is number one. Then number two, the client then tells you that, you know what, I'm having a problem with this gentleman. He's owing me money, but I know that we can still do future business together. So two things: I want my money, and I still want to maintain the business relationship with the party. So what form of dispute resolution are you going to look at? You can't look at litigation. You understand? You can't, because definitely if I get a judgment against you, I get my money. Do you think I want to do business with you? So mediation is in line with the conversation of the 21st century. Mediation is the technology of dispute resolution in terms of speed, in terms of efficiency, in terms of possibility of restoring business relationships. And guess what? The people are now beginning to come to that realization. So it's no longer a question of if, but a question of when.
My next question is now, you've mentioned that litigation is party driven.
Mediation is party driven.
Yes, it's like party driven, right?
Yeah.
Yeah. So now, one thing I want to understand, because if let's say I'm a human being, just a regular guy on the street. I've just signed an agreement with a large organization. I want to do a contract. There's a breach. I want to do mediation. Now, me as a human being don't have the experience of the organization, obviously, in mediating. Now, if I decide that I want to call for mediation, as a mediator, how do you hedge against that imbalance in negotiating power, negotiating experience? Because when you come to the table, it's like we're both trying to agree things. What is a structure of a mediation conversation that makes it that me, as the regular guy just trying to get paid, I'm protected against this mammoth organization that has all the time, all the resources, all the everything to deal with me?
There's a gentleman that has a problem with another company, and then he wants to go through mediation. It's one of two things. It's either he walks into any area organization and then file what's called like a statement of issues, and then the area organization would invite the other party and then want to mediate. That's one. Number two is that he can get a lawyer who can then write to the other party and say they want to explore mediation. Now, when you then have both of them on the table wanting to mediate, and of course there's an imbalance. There's a big fish and then there's the other person. But at the end of the day, he has rights. And that's why we have the concept of justice. He definitely has what he wants. So if at the end of the day it's on the table and the other party feels that he or she does not want to consider what it's there or what there is, then the mediation can end and then they can go to court and have the issue resolved. But at that table, the fact that one party is a big fish and whatnot does not really come into place. What comes into place is this: what do they want? What do you want? Do you want money? Now, why? Okay, now, so there is something that we call position. So position is what you want. Then you have the interest. The interest is why you say you want what you want. So if you're asking for probably #1 million, the question the mediator would ask is this: what do you want? So what you want is your position. So let's say you want maybe #1 million, and then the next question is, why do you want #1 million? So how did you arrive at that #1 million? That is called the interest, the justification for it. And usually a good mediator takes parties from the arena of position, which is what you want, to the arena of interest, why you say you want it. That is the level playing ground, because By the time you then start listing out, okay, fine, I want 1 million naira because I suffered XYZ, 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 XYZ. Even to yourself, you know that maybe what you're asking for is not even up to that amount. You know, and then the other side would also look at the basis upon why you asked for some of these things. But don't also forget that even the big fish is also looking at his legal expenses. Why? Because one, he has probably sent a representative from his organization, you know. So and the representative is already being paid a salary. So you and then ask yourself one question: that if we don't come to an amicable resolution, and we need to bring an external solicitor in, there's a charge, there's a cost ascribed to it. And you know, where commercial businesses are involved, it's all about the money. You know, everybody's looking at how to cut legal expenses. Everybody's looking at how to manage expenses. So it is to their own advantage that anything that can be settled should be settled. Because now, if someone's probably asking for maybe 400 or 500k or a million naira, and you then decide to bring in an external solicitor, you know, you're going to pay the solicitors his legal fees now. So you then do a bit of weighing. You ask yourself, even if you have to pay the solicitor, which is not even possible, maybe 200k, does it not even make sense that you probably add some other thing and then settle? But of course, also understand that even on the path of the organization, they're also thinking of a lot of things outside of the money. They're thinking of not wanting to set a precedent. They're thinking of not wanting to encourage certain things. But then again, where mediation is concerned, nobody needs to know that parties have come into settlements. So the fact that you have been able to settle a dispute with A and both of you have entered into an agreement does not mean that if that scenario repeats itself, one party can say, oh, but you gave this person 500k and all of that. No, mediation doesn't work that way. You know, it's based on what the conversation is. And then the question is, how did you find out about that conversation? Both parties signed an agreement among so many other things. So the short response to your question is that when it comes down to the nitty-gritty of it all, the imbalance, who does it really favor? You know, it doesn't, because don't forget that whatever you offer, the other person is at liberty to choose to accept or not accept. It all goes well. It all goes well for you to, you see, people who benefit more from mediation are people that are transparent. People who lay their cards on the table. You know, because you see, mediation goes down to the very nitty-gritty of what the issues are. So if you are then holding your card to your chest, trying to see, oh, how does this go on and all of that, you're not going to help the process. And that's why when people come into mediation, a lot of times they come into mediation with the mindset of litigation or the blame approach. You know, once the mediator is able to explain things to them, then they move from there to a problem-solving approach. And that's why a good mediator will not look at a problem as A against B. It is an issue of A and B against the problem. And then you take it up from there. You'll be very, very surprised at how
A and B against the problem.
Yes, because obviously there is a problem. You know, so it's not A against B. You know, it's not it's not the people. Yeah, it's not the problem. It's not A against. It's not people against people. You know, so what is the problem? The problem is the money. What is the problem? The problem is unlawful termination. You know, so what you then have is, okay, fine. So this is what the problem is. You know, so can both of us work towards resolving that problem? You know, and then you take it up from there.
All this being said, okay, at what point in the conversation do I call for mediation? And I'll tell you what I mean. I think let's use something as basic. I think one of the most signed contracts in Nigeria is an employee contract. In my opinion, I think it's,
from your own point of view,
at least as far as I'm concerned, it's just every day there's an employee contract being signed. Now, at what point can I say I need to go to an ADR organization to call for dispute resolution? Because, you know, like you said, if you want to resolve something and still keep your relationship, because if you look at employer-employee relationship, any sort of dispute from the employee sometimes might not really result in you keeping that relationship.
I agree.
What point does the employee come and say, okay, this is different from what I understood from my contract.
Okay.
Can I call for mediation? Is it even possible for an employee of a company to say, guy, I want to mediate this contract? And does a contract need to carry mediation as a line for me to say, I want to go to an ADR organization to request for?
Okay. So your questions are layered. The first question is this: at what point in time do you call for mediation? If there is no dispute, there cannot be any mediation.
Great.
So what gives rise to mediation is a dispute.
Okay.
And, when I started up, I tried to explain dispute is a misunderstanding. The synonym of dispute, misunderstanding, conflict, disagreement, and all of that. So what gives rise to that brings about mediation is the existence of a dispute.
Okay.
So if there is no dispute, there can be no mediation. So now let's come back to what you have just explained now. Okay, an agreement. You've noticed that there's a problem with that agreement. So you have issues with that, with what is there. So definitely there's a dispute has already arisen. And the dispute does not necessarily have to be overt in terms of, because if it was something that could have been immediately resolved, you may not need mediation. So what has happened at that point is that there is a dispute at that particular point in time, and you're then looking for ways of having it resolved.
Okay.
So what do you do at that particular point in time? Now, you see, we can talk about negotiation. So negotiation is communication for the purpose of persuasion, when you're trying to basically trying to look for a better way of doing things. Negotiate. We're trying to negotiate. But you see, when mediation is concerned, a dispute has arisen. So what have you done? You have reached out to the other party to say, look, you know what? This has come up. Is there a way we can have this issue resolved amicably? But now don't forget, if at the point where it's just a conversation between two parties, it's negotiation. Yes, it's negotiation. So mediation comes about not only when there is even a dispute, but when you then bring in someone who is trained in the art of resolving disputes. That is basically where mediation comes into place. So if you don't have an understanding of mediation, even though people tend to use that word loosely, there was a disagreement between two parties, I tried to mediate. Yeah, then the question then comes up now, okay, fine. In trying to mediate, how did you mediate? What steps did you follow to mediate? Because you see, when we're talking about mediation, there is a structure that needs to be followed. It's called, if just leave a crash course on it, it's a six-tiered. First, preparation on the part of the mediator, where the mediator first of all goes through the issues before coming into the mediation to have an understanding of what the issues are. After preparation, you have O, which is the opening statement. That is when the mediator then tries to give both parties a crash course on what he's going to be doing over the next couple of hours, explaining that, okay, fine, this is what mediation is. These are the features of mediation. It's confidential, it's voluntary, it's without prejudice. You explain those things. You also leave what's called ground rules. Now, then when the parties then speak, then the mediator then generates what's called an agenda. So what an agenda means, what is the problem? What are the issues? Now, the agenda is clearly spelled out. Then the mediator then asks, okay, fine, is this what the issue is? If you say yes, then that will then form the agenda. So you don't even come in midway and then start coming up with other ancillary things to expand the scope. So can you see the structure that is in place? That is the agenda. Then when the mediator then extracts the agenda from you, he then asks the other party for his reaction to what the agenda is. So the party can say, I agree with this, I don't agree with this. So there's a bit of, I like to use the word intellectual ping pong between A and B. Now, even though the agenda has come up, which is usually the position, the mediator then tries to extract the interest to find out from the party that has brought up the agenda why he has asked for what he has asked for. Then the mediator then helps the parties to explore options towards settlement. Now, once the parties have been able to agree, now look at the next structure, then whatever both of them have agreed upon will be in writing, duly signed. At that particular point in time, that agreement becomes binding. That agreement becomes a contract. That is a structure that makes mediation different from a regular misunderstanding, that makes mediation different from a disagreement. Can you see that structure? It follows the level of professionalism in place that the mediator brings about. Because we can have, if both of you have an agreement in principle, but there's nothing that is written to that effect, and you then step out of that mediation room. So what is the evidence to show that you indeed agreed upon it? Now, if you then renege, so how will you be able to then enforce those terms? So it's that structure that comes into place that makes mediation different from a disagreement.
So would it be safe to say that have you ever had to mediate an employee contract before?
Oh, quite a lot. Oh, quite a lot.
Before the employee left the company?
Oh,
or
well,
while they are still there?
So some organizations have an internal dispute resolution process. So what that essentially means is that when right from the employee handbook, it's stated that when disputes arise, before you decide to explore other options of having disputes, before you explore other options, you should first of all try and have the dispute resolved. So they have what's called like an ombudsman. Those are independent, neutral mediators. They don't work with the organization. It's like an adjunct of that organization. So it's even different from the HR systems and whatnot. So if any dispute comes about, you can notify the HR and let them know that, look, this dispute has come about, and I would like to have this issue resolved. Then they bring in the onboard, the neutrals to look at what the issues are and then resolve. And then so it's pretty much the same framework, both of them are still working in the organization. So, and more often than not, it's always between a line manager and a superior or something like that. So it could be that the subordinate has a problem with the way and manner the line manager is speaking to her. The last one I think I had a couple of months ago. So it had to do with the condescending way in which she was being spoken to, and he had a problem with it. And he had to complain to HR about it. HR didn't do anything about it, and they felt they needed to bring in a mediator, and they agreed. Yeah. So what happened? They brought in both parties, and they explained. And apparently, that was the other party's mode of communication. And I remember she said something that was a bit. She said, "When I was his age, when I was working in XYZ, I would not leave the office unless my boss goes." And you're like, no, but it doesn't work that way anymore. This was the approach 10, 15 years ago. So if my agreement says that I'm supposed to resume my work at 9 and finish at 5, that is the same thing your agreement says. So if you decide to leave the workplace at 6 or 7, it's a matter of choice. So you cannot keep me down there. So it was an issue, and then both parties agreed, and then you took it up from there. There was also another one that was handled that invariably we had to advise there had to be some kind of transfer, because it was clear that both of them were alpha egos, and one person was not willing to leave one person was not willing to budge. But then again, the seniority cadre had to be respected, and that is quite a lot actually. Yes.
So, but because what happens when and I think, because I'm going into this because I feel if this is something employees could do, is actually take this instance of condescending way of speaking to people. I think it's something that is becoming big in Nigeria now. Without anything being done, people will just be telling you, oh, they curse your grandma, they curse your uncle, they curse everything. They tell you you are this, you are that, all those sort of things. And I see it a lot. And a lot of times, even when you try to make sure it's not done to people, you are not everywhere. You're not Superman, you're not everything. So do you mind explaining to me, if you were to advise an average employee and say, this is how mediation can help you at work. These are the scenarios that basically how you should act. Because in Nigeria, we're very unforgiving when people tell us, I don't like the way you're doing this thing to me. We can be very, I'll see you later. I'll deal with you later. All those sort of things. How do you protect yourself through mediation? Is it?
Your question falls within the arena of workplace conflict, which is also a flavor of mediation, and essentially that talks about disputes that happen in the workplace. So the question now is this: it has to do with the organization itself, which is usually the starting point.
Okay.
What mechanisms do they have in place when issues come up between employees? Now, for some organizations, those issues are always resolved using the HR, that is using HR. But sometimes the employees feel, look, the HR is part of the system. So the HR will basically try to balance. So the question now is that what are the mechanisms in place? Now, for some organizations, they've said, you know what, we can actually, quote unquote, frame out this element of workplace conflict to independent neutrals. They don't work with the organization, but if you make a request, then both parties can be invited, and then you look for a meeting point of some sort. So if that organization does not have that type of mechanism, it's always a bit difficult to bring it into place. So if you then have that kind of issue coming up, and realistically, let's be, if I'm still working in an organization, I have a problem with my boss or something, then it's only ideal I talk to the HR about it. But if I then decide to institute an action for mediation, it then becomes a case of, okay, but both of us are still working in. So in reality, how does that play out?
That's actually my point. It's like,
how does that play out?
It's really tricky.
It's tricky, it's tricky. But if you have, like, some organizations have those kind of internal mechanisms that encourage conversations like this. So if those conversations exist, yes, you can put it in place. And that's why, apart from even being, we also do a lot of facilitations, whereby there's another arm of Fortify Mediation Academy, where we basically train people on resolving disputes amicably. So we go to organizations, we explain to them the need to have internal mechanisms to have disputes resolved amicably. And a lot of them actually buy into it. A lot of them.
I think that's an evangelism that needs to.
Oh, a lot of them.
That needs to.
Yes, because apart from even issue of workplace conflict, emotional intelligence, apart from emotional intelligence, interpersonal relationship, then this question of most times when I train, I would ask this question: is your colleague your friend? You understand? So at what type of relationship should be encouraged in the workplace? So when you talk about friends, he's my guy. Both of you there's a shared value, but in that workspace, the values that come in with friendship, is that the same values that one should look at where colleagues are concerned? So the interesting thing, Amida, this conversation is going on extensively, people wanting to know how to manage workplace conflict, because a lot of times what they say is that, look, it is better to treat a sore before the sore festers into a wound. So before it gets to the point where one person say he wants to sue the other person, he wants to sue the organization, if we have internal mechanisms at play to manage it, at the end of the day, prevention, quote unquote, is cheaper than cure. And that's it.
Okay. So let me leave that topic with. But now, so let's assume you've gone through litigation. Is mediation still open to that sort of person?
Oh, yes, it is. Oh, yes, it is. Because now, you see, in the court system, we have we have court referred matters. So what that essentially means is that you have filed a case in court, you're before the judge. Then the judge most courts have what is called, I know of Lagos for sure, an ADR track system, where they look at the case and then then decide on whether this is a case that can be resolved through mediation. So the judges then recommend for those cases to be sent to mediation. And yes, so this matter is still going on in court. It's happening at the High Court, which I mediate. It's also happening at the Court of Appeal. But let's talk about the High Court. So they look at the facts of the case. The case is referred to mediation. Now, the beauty about it is that at mediation, if parties settle, now whatever it is they agree upon will be written in form of an agreement. Now that agreement will be taken back to court and adopted as consent judgment. So the implication of that is that rather than have the case spend 2, 3, 4 years in court, the fact that they have both agreed is expedited. Even with divorces, you can actually even bring in mediation. So let me even speak about this. You see, mediation cannot dissolve a marriage. I need to state that. Mediation cannot dissolve a marriage. But mediation can handle the contentious issues. And when we're talking about contentious issues, we have the issue of custody.
Okay.
We have the issue of maintenance. We have the issue of access. And it would interest you to know that a lot of people are now beginning to bring in mediation in their divorces, because please understand that the courts are courts of public record. When you say court is a court of public record, what that means is that you can just walk into any court, sit down and observe proceedings. So you don't want a scenario whereby dirty linens are being washed out in public. But with mediation, within the confines of privacy and confidentiality, parties can have the issue of custody resolved, have the issue of maintenance issue resolved, have the issue of access resolved. Once all of that is done, that is taken back to court. It's also adopted as consent judgment between both parties, and the court then dissolves the marriage. So you see, when that happens, you find out that negativity, that rancor between parties are properly managed. So mediation is like a key that can practically open any door at all. It just depends on the way and manner that it is being used. And I'll tell you for free that I've been doing this for 10 years. This year marks my 10th year. The speed at which mediation has been moving in the last 5 years has been amazing. Now, I don't know whether it was because of COVID that happened in 2020. You see, when COVID struck, and now people are now looking for more convenient ways of having disputes resolved. Rather than having to go to court, you can sit down in the comfort of your own to have issues resolved through what is called an online dispute resolution. People are now thinking of faster ways of having disputes resolved, and that's it.
Okay. So
that part is going to be manageable.
No worry, you leave the rest for me.
Okay.
So I have two more questions. I think the first one, since I've known you, I think you've been one of those people that is extremely passionate about the topic of mediation. But I've never really got to the point where I asked you why. So why this? Why are you not just practicing regular law? And
why mediation?
Why do you enjoy sitting there in the middle of two people that want to just eat each other across the table? If you had like big chest now, like you have muscle like this, I was okay, yes, maybe you enjoy doing like this and everybody else sit down. But why?
Why mediation? Now that's a very deep question. Why mediation? Okay, so let's start off from 2015 when there was this case I was handling that I mentioned for 4 years, and this matter was referred to mediation, and in less than 6 hours that the matter was resolved. That was the first time I heard about mediation. But there's also a backstory to all of this. So I'm going to go back to 2001 when I lost my dad. Now, I was on scholarship then, and I think as it was the time when I was in year 2 when my dad passed away. I was on 2-1 then, but losing him, with all the issues that come with losing your dad, family members and whatnot, I failed all my courses in year 2.
Wow.
Yeah, everything. I think by the time I got to year 3, failed first semester, failed second semester. From a 2-1, I literally dropped to a 3rd class. From 3rd class, I think I moved to a pass. Now, you see, there's something that does to you mentally, because you subconsciously see yourself as a failure. And I struggled, Amida. I struggled with that till I got to year 4. Year 5, I had an extra. I finished with a solid 3rd class from Unilag. Got to law school, finished with a pass. Then I came out, and getting a job was difficult. Passed 3rd class and all of that. So the only place I could work was a litigation law firm. And the only reason why I could even work in that litigation law firm was because my uncle was the managing partner of that law firm. So I didn't even exactly get into that place out of merit. It was because my uncle looked at me, he had a conversation with me, he saw the fire in me, he saw that determination, that zeal to succeed, and then he took me in. But that also did something to me, because in my mind I was like, wait, it's bad enough that I finished this 3rd class. So am I saying now that I don't even have what it takes to get a job? And that stayed with me for 10 years. In between, Amida, I tried to do a master's to just give myself that semblance of the fact that I could amount to something. I failed masters. Please, who fails masters? Please, who fails masters? You understand? And at that point in time, I just said to myself that, look, you can amount to nothing at all. I tried to leave the litigation to get another job, but I had issues there again because I could not keep up with litigation. So, and mind you, I was working in a law firm that had the highest number of sitting SCNs. That's at that time. I think we had about maybe 4 or 5 SCNs there. So, we ate, drank, slept litigation at every point in time. But I still did not feel that connection up until when I accidentally stumbled upon mediation. I'll tell you one thing. You see, mediation gave me a new lease of life. And I said, what the moment I found out about mediation, I said to myself that this is something I know I'll be good at. So it did not even matter that in 2015 that I did not know anybody that was making money from mediation. It did not even matter that when I checked online, I did not know any bespoke firm that was into mediation alone. It did not matter. This is where passion comes in. You know how many people advised me to tell me that, Fola, look, you're going to go hungry. Go and check. Is there anybody that you know that is making money from mediation? Do you have anybody that is doing mediation as a sole practice? So I said something. I said, if there's one person that's going to make money from this mediation, that one person will be me. Because first of all, it gave me a new lease of life. It brought about my sense of self-confidence. You understand? And it has basically opened doors for me to the fact that I not only mediate in Nigeria, I train with over maybe 8 ADA organizations around the world, and I have trained professors, I've trained scholars, and I sit back and in my mind, I'm like, look at you, Fola, you that finished with this thing now, look at what mediation has done to you. So the passion that you see is not only the fact that I have been able to reinvent myself, but to show that that has also made me rediscover myself to take things from point A to point B. So when you see me talk about mediation, I talk about mediation because I love mediation. I do actually.
I think that's deep, and I think one of the things that a lot of times we do. I always like to put this in that I think I fall into the same boat in terms of passing and failing subject. So me, I was one of those kids that a lot of people don't know this, right? Is that the biggest, if you told me at any point that you are writing an exam and the exam is for you to write your name, there's a 99% chance, there's a high chance I'll fail it. Anytime you tell me I have to
Welcome to the club.
write exam,
That phobia.
so which is why even when I started this podcast, it was always a problem. This is how it should look. One day I was like, you know what? Let's just start. I wish I could show you. I know when I was looking at the video we posted about how we published the studio, that wasn't actually the first version of the studio. The first version of the studio was just black cloth around the wall. We just put a chair and I'll just sit down there and we talk. We never published any of the episodes. It was bad. But then it was fun. So eventually I warmed up into just being myself.
Just authenticity right there.
And that's just it. And I was like, and people were like, oh, I said, no, if anybody does not like what I'm saying, thank you very much. We would say it anyways.
Exactly.
If people that like it, thank you very much. People that don't like it, okay, don't worry, don't be angry. Go and watch the people you like. Because a lot of times, if we only understood, if we can look beyond those stuff, I know how much I would like. I was saying to my friends then, I said, I know I can talk. I know I can think, but I can't pass the exam. So I need to find a company that will see that side of me. Not a company that just like, we need 2-1. And you're like, where would I see 2-1? I don't have 2-1 now, but I don't want to even talk to you if you don't have 2-1. We need a place that has first class. I don't want to talk to you if you don't have first class. And you're like, I didn't know another experience I have, right? This one is funny.
Tell me about it.
In my whole career, every time that I'd gotten to the point where the office is fine, like the office is just fine. You know those fine office you
It's possible, exactly.
Anytime I go to that point, I will lose the job.
Wow.
I've never been a man of structure. I was working with IHS and they were in Aboya Adeko, amazing stuff. We moved to one place that was fine. Poof. I had to go to Rwanda. Go to Rwanda in a shack, a raggedy office like this. The moment we start touching it up a bit, oh yeah, Ilea. I was working just everything. So most of the time, I found out that I'm one of those people that have had to build
From scratch.
the life I want for myself, more or less. It's not if I wanted to that I work with someone that is like, oh yeah, this is fun. No, I've never been that lucky. Some people are lucky that they're working in like Chevron, Shell, and the band. I'm like, oh my God, I wish I could work here. But it didn't work. But the point is, for me, I've just found out that sometimes our destiny will always find us.
Without a doubt.
Eventually.
And, yeah. And to even add to what you said, so for me, for the longest time, there was this mental scar of finishing with it past and I thought class. And I saw this scene in a movie, Game of Thrones. This guy, I can't remember his name, this short guy.
The dwarf, yeah.
The dwarf, there was something he said to Stark, to Jon Snow. He said, look, when you wear your weaknesses like a badge of honor, nobody can use it against you. And that's what I'm doing right there. So whenever I train, whenever I facilitate, I tell people, look, I finished with the third class and look at me today. So your grades should not determine who you are.
My own is I am arrogant. Just know. If said I am proud, I'm arrogant. Just know now I am.
So exactly. So I say that a lot, and even those that work with me, whenever we're having interviews and they start bringing out I tell them, look, the most important. This is what I look out for. I look out for passion. I look out for tenacity. I look out for hunger. These are the things I look out for, not what you finished, what you came out of school with.
Yeah, I'm even worse. I didn't even look for anything. See, because there was a time they gave me a list of what I forgot where I was working there, and the HR person came and said, "This is the way we want to be hiring. These are the qualifications we want in people now." Now I said the guy was discussing with me because I'm one of the star performers, and it was like, so we need to start getting references relating to this, and I said, do you realize that you would not have hired me if these criteria were the things you used when I was coming in? And the guy went silent. I think I remember what I'm working on. The guy is in London. He's retired now. Was the HR person then. And he went silent. And he goes, how do you mean? After, when you just, I said, first of all, you say you need a first class or a 4.0 GPA. I had a 2.4. Second class lower. You say you need an Ivy League school. I went to OSU. You said, you say you need to and so, and I just went boom, boom, boom. You said you need this years of experience. I had like 5 when you hired me. The guy was like, So I guess you need to rethink this. I said, yeah, I think you have to. Because the point is, a lot of times, we sit down, we tell ourselves, I got it. No, we figured it out. But no, you don't.
You haven't. And I think
you're just passing through.
Yeah, and the takeoff from what you said that you see, success is not on us. Success is in us. Because everything you need to succeed, you have it. So, what can I say? I guess we would have lucky covered.
I mean, for me, I've just learned to just one day at a time. I always say, see, the biggest win for me in my own life, I get to my bed and I just sleep. If I say today, once I get to my bed, put my head down, I've won. Trust me, there is nothing. I'm one of those people that when I enter my room, my wife knows me, I enter my room
1 minute,
3 a.m. 3:04. I can't even remember anything. I'm gone. I sleep with zero worry. Because my own, honestly, trust me, I've come to the point where the things I chase don't define anything anymore.
Fantastic.
So if I chase anything, I'm just chasing it for. You can think that I'm vibing. I'm just. So trust me, I've been in places where like when this thing wastes your time, I say, no. Me, I can go this on 10 years. It doesn't hold me at all. I am that fine with things now. Because I've come to the realization that in life, you never really, really win at anything. You might what you call a win, and it's a simple scenario. It's like you buy a car, you feel like you're amazing, things are good. 2 weeks' time, you drive the car into a crowd and you've killed somebody. Wow. What did you do? Did you win? or just say you fell from somewhere. You thought you fell down. You know, I thought IHS was a big that I failed. Like literally, I got there and one day they just woke up and said, boom, okay, it's time to go. We need to separate. I'm like, okay, great. But guess what? I went ahead, took another company, turned it around, made it this thing. I'm here, still standing. You never really know
You never do
what is a win or a loss.
You
We
never
work
do, actually.
every day. You know the funny thing? You work every blessed day. Like, look, and it's a simple. You read stories of people, all these heroes. This guy that fought the Scottish guy that fought the British, that a Braveheart movie.
Okay, Mel Gibson, right?
Yes.
Okay.
I've forgotten his name. Okay, the guy. And I kept looking at the distance. He fought them for years. But one day, he got caught and killed. And the thought in my head is, who won? At what point did people declare wins? The British went ahead to fight a more elongated war after they killed him. And then, but before they killed him, who won? For his son, his daughter, who won? Because we do these things like there is nobody behind that figure. So when people say, okay, yeah, let's mediate, no, I don't want to do it. I've been in too many situations where people are just like, no, go and do your worst. We have one Baba Saleh somewhere, and you're like, I always call some people who's Adubos, like, if you're in a dispute with them, just raise up your hand and say, where? Because there's nothing, you just feel like, so you still, why do people treat each other so, where is regard gone?
Yeah, people do the best with what they can. If they know better, they will do better.
Exactly.
Yeah,
But you know the funny thing, that there's, because I hear this thing, I was listening to somebody and it was like, oh, on your way to the top, you have to be ruthless. And I'm like, technically, I don't think you've gotten to the top. That's what you're saying.
Exactly.
People that are ruthless, I don't even understand what that top means. Everybody say on your way to the top. What top?
What is the yardstick?
Yeah, but okay, let's even assume. Oh, you want to be like Elon Musk? Really? You think he was ruthless? That's your own, because he did a negotiation that you read the paper version of. You think, oh yeah, he was ruthless. So, because all of us, we just read paper version of everything. Oh, according to Jeff Bezos, he sat in his office, worked for so and so. He gave up everything. A guy, you're speaking, need go school, go do recital. Don't follow him. When you don't follow him, wait. Try to be like that Elon Musk. Yeah, better make sure you get there, because that Peking, he has memory too, and he's somebody.
Yeah, well said.
But it's honestly, for me, it's been an amazing session. Really, I think we one of the things I really wanted to do today was to actually try to get to the point where it's easier for people to just understand mediation and why it is required. Because there's a lot of things in Nigeria that people don't have a clue about, and I think this has been a very insightful one. So yeah, really, Fola, I really appreciate it. Thank you very much.
Thank you so much.
I really appreciate it.
Thank you.